To transfer an interest in real property, a deed must be delivered to the grantee. Delivery is ultimately a question of intent, as illustrated by the 2004 case Blancett v. Blancett. 79-year-old rancher Richard Blancett drafted two deeds. One of the deeds granted a remainder interest in the surface estate of certain property to his son, Linn Blancett. The other deed granted a remainder interest in the mineral estate of the same property to Linn and his brother. In 1993, Richard gave both of the deeds to Linn's wife. According to Richard, the deeds were just a temporary solution until he could draft more formal estate documents. Thus, he instructed Linn not to record the deeds unless he died or did something completely crazy before drafting those documents. Several years later, while planning his estate, Richard drafted a will and a limited family partnership agreement. Those documents, which distributed the same property covered by the deeds, gave Linn less property than the deeds did. Subsequently, in 2001, Linn recorded the deeds against Richard's instructions. Richard sued Linn in New Mexico State Court, requesting to nullify the deeds on the ground that they were never delivered in the legal sense. The trial court found for Richard, nullifying and canceling the deeds. The Intermediate Appellate Court affirmed, and Linn appealed to the New Mexico Supreme Court.